Good evening, I am your host from PV Legal. What if the order authorizing your arrest was sitting in a government file and nobody was required to tell you it existed? For 9 years, that was the position under the GST law. Today, the Supreme Court has changed it. The case is Union of India versus Sunil Biyani, decided on the 12th of August 2026 by Supreme Court. The Union of India was the appellant. The respondent was a businessman under investigation by the GST Intelligence Directorate. The dispute was narrow. The consequences are not. The Directorate General of GST Intelligence in Mumbai was investigating a group of companies for wrongfully claiming and passing on input tax credit without any real supply of goods or services. 3 summonses were issued to the respondent under Section 70 of the GST Act. He did not appear. He sought adjournments and then applied for anticipatory bail. The Sessions Court refused. The Bombay High Court also refused, and its reasoning was straightforward. No order authorizing arrest had been passed, so there was no apprehension of arrest. So the application was premature. But having said that, the High Court then added something. It directed that if such an order were passed, the respondent would not be arrested for 1 week. The Union of India appealed against that direction alone. 2 questions arose. First, can a court that dismisses an anticipatory bail application as not maintainable still grant the applicant protection from arrest? Second, must the Commissioner's arrest authorization under Section 69 of the GST Act be communicated to the person before he is arrested? The court answered the first question no, and the second question yes. It drew on precedents from 1951 and 2014. It also relied on the recent judgment in Radhika Agarwal. On the first question, the principle is old and simple. Interim relief exists only in aid of the main relief. If the main application fails, nothing can survive it. The court held that a High Court or Sessions Court dismissing a pre-arrest bail application as not maintainable cannot grant protection. The Bombay High Court's 1-week direction was set aside. On the second question, the court accepted a catch-22 argument. Without the Section 69 order, you cannot apply for anticipatory bail, and if nobody tells you the order exists, you never get the chance. So the court read a requirement of communication into the statute. The order may be sent by email or mobile. The details used will be those already on the GST registration record. And then the court said this, in words that will be quoted for years, without such communication, the question of arrest would not arise. Here is what this means on the ground. For the department, the arrest file must now survive being read by opposing counsel. For businesses, the old tactic of filing early and hoping for a protective order is finished. It is time to update your strategy. Instead, keep your registered email live, keep your papers drafted, and be ready to move within hours. For the full legal analysis, read PV Legal's daily newsletter. I'm your host from PV Legal. Stay legally informed, stay alert. Good night.